name. And he's back there waving at you. Do you want me to give you his name, or do you know him?
No,
Okay. And second, if you could open us up in a word of prayer.
Thank you. I'd like to introduce my friend, Judge Tankel. Sadly, he's going to be retiring soon. He can't even finish out the year. I don't understand that, but he and I work together on veterans courts issues quite often.
Awesome. Welcome.
And if y'all would join me in prayer. Dear Heavenly Father, thank you for another beautiful day in Georgia and for the extra day of rest that we had yesterday. As we approach the fast-paced part of the session, give us strength and peace and also courage. In Jesus' name, amen.
And thank you. Speaking of the fast pace of session, tomorrow is a committee day. We'll be meeting at 9 a.m. I think most of you have already seen that, but 9 a.m. tomorrow we'll be back to hear some other bills. So we'll start tonight, this afternoon, with Senate Bill 378, Senator Albers. We're working off LC 490723.
That's correct, Mr. Chairman.
And the floor is yours. Speaking of cancellation, your mic's not even on.
Oh. Well,
welcome, Senator Albers. Please tell us about your bill.
Well, Mr. Chairman, it is an honor to be here before your committee today, and I'm going to be very brief today, as you've given me probably more time than I deserve. We passed this bill, again, just for those who are listening, twice out of this committee unanimously, twice out of the Senate unanimously. 2020, it passed, but when we got suspended for COVID, did not get through the House. And then last year, during the time frame that was in committee in the House, unfortunately, I was dealing with a personal cancellation issue. So with that in mind, the House did strip our bill down to a fraction of what it was, just leaving in the basics of defining what hazing was, as well as the general reporting. All this does is restore the exact same language that we have passed those other times. This will save lives, and not only the 200 that have lost their lives over the last 20 years, but really in honor of Max Gruver, a young man who lost his life, and his mom and dad who are traveling today, who are going all over the country, still meeting with different organizations to help them. Steve and Rayanne Gruver, I hope you're listening right now. Thank you for your amazing work on this, for the legacy of Max. And we seek now to just, again, restore this language to where it was before. Thank you.
Thank you, Chairman Albers. And so to be clear, the language in front of us with this LC, this is something that we voted on last year. Is this exact same language?
It's identical language.
Okay.
Correct.
Senator Parent has a question.
Thank you, Mr. Chairman. Thank you for your continued work on this issue. Senator Albers. Okay, so two questions. So Max Gruver, who you just mentioned, did the bill that did make it all the way through, that's named that? I noticed that you don't. Okay.
That is correct. It's in the law.
Okay, so what are the pieces that actually did make it in?
Last year, obviously, the name of the title, they defined hazing throughout the first section, or actually it was section 2 technically. And then in the last section, they put in some basic reporting for what happened, but they took out all kind of what we call the meat of the bill, if you will, in the middle, and that's what we're really adding back in there.
So definitions and
the provisions for if they did
reporting.
It being a felony as well, yes.
Okay, thank you.
Thank you.
That's helpful.
Any other questions for Chairman Albers from the committee? All right, thank you. We have one person signed up to speak. We have Miss Maisie Lynn Guertin with Georgia Association of Criminal Defense Lawyers. Good evening.
Good evening, Chairman. Thank you so much for hearing from us on this legislation again. Although I definitely see the spirit of the bill being exactly the same as Senate Bill 85 from last year, we did notice some language changes in this version when we reviewed it. As a matter of policy, GACTL is always concerned when we add felony crimes to our code, but we're especially so when those who are going to face prosecution are young. There's a great deal of current research, as your committee has heard over the years, on adolescent and emerging adult brain development, discussing how critical it is to consider the undeveloped brains vis-a-vis criminal culpability. The reality of this underdeveloped brain situation for young people seems to be accounted for in Senate Bill 378. You'll see on lines 98 and 99 of the current LC that it does prevent expressed consent from being a defense. So I think that seems to account for the idea that, you know, these children that are potentially the victims of this offense can't expressly consent to having it happen to them. Unfortunately, though, those same children can be prosecuted for this type of behavior under this bill. There's also some dissonance in this bill, and this is something I talked to you all about last week in another context. That is how we conceive of 17-year-old children in our state, specifically in our criminal code. Here I'm speaking to lines 78 and 83. While I can follow the author's logic in light of the fact that our code today currently conceives of 17-year-olds as adults when criminal liability is an issue, it seems dissonant to consider a 17-year-old a minor in those times when she's an alleged victim, but shift that same child to an adult in context when she's alleged to have committed a crime. There's no obvious reason to us that a 17-year-old would not already be held accountable in the typical course of prosecution, because we do today handle 17-year-old children as adults in our system, even if those lines 78 and 83 were not so specific that you had to be 17. So our aim is not to ask for any modification here, because there's no modification you could make that would correct the fact that we're treating 17-year-olds in such disparate ways, short of passing raise the age when it comes back before you. Hopefully it will. Instead, I just want to raise this issue to you because I promised you last week that when we continue to see this dissonance in our code, especially our criminal code, around 17-year-olds, I just want to bring it to your attention so you can see how prevalent it is in the laws that you are asked to consider and pass. Shifting back to those aspects of the bills that you could modify, when you consider media reports, and even I can think about my own college experience, most of the behaviors that would be of concern in the hazing context are already subject to criminal liability under Georgia law. I will admit, though, outlined in Senate Bill 378, I cannot divine a current alternative for what would be forced alcohol consumption. But it is critical for you all to note that when there are overlapping offenses and overlapping punishments in our code, issues of merger and issues of lenity come to the surface and have to be accounted for. It may well be that those issues have to be resolved through litigation, but it does seem worth noting for your consideration that those could be in play here, considering that a lot of the behavior in this bill is already criminal under our code. As we discussed last year, we continue to have a concern about the idea of force. This shows up first at line 21 in the bill, and how broadly that term could be construed. There are certainly behaviors that if any of us saw them, we would agree that some amount of force was used or involved. When it comes to alcohol consumption and the felony that's described in this bill, we do wonder just what behaviors constitute force, and suggest that a more narrowly tailored language would ensure that the net is not cast too broadly than anticipated. For instance, is there some level of verbal encouragement or cajoling that you could envision rising to a level of force? Or do you really want to target physical actions of force? It's not clear in the language of the bill as it's drafted today. There are other terms in the bill that strike us as either vague or typically creatures of civil code, civil actions, things like personal injury and tort liability, rather than being creatures of our criminal code. In the criminal code, we usually rely on things like mens rea and intent. Those are paramount to establishing crimes in the criminal code. So when you look at, for instance, lines 21 and 26 and talk about endangering or being likely to endanger someone's mental health, when you talk about severe emotional or physical distress at line 35, an unreasonable risk of harm at line 39. And this is one of those parts of the bill where we perceive, and I could be misreading it, that there was, in the prior version, a requirement that there be a verifiable harm component, that has been removed in this version. Another phrase would be rendering reasonable assistance. This is found at line 94. And this is interesting to note too, because there's kind of a corollary idea. This is at line 94, what you see is there's an idea that if you provide some kind of reasonable assistance in good faith, you are prevented from being subject to any civil or criminal liability. We have this concept in other parts of our law. For instance, we have it in 1613.5. This is related to occasions where someone might report drug use in order to get help, and then that protects them from certain types of criminal prosecution. And it just seems to be at odds with what's happening in this bill potentially. I just bring that to your attention. And I think it's also worth noting in that corollary, and I call it corollary, maybe that's not truly the term of art that applies here, but in 1613.5, in the rubric there, that code section actually defines phrases like what medical assistance is. It defines what seeking medical assistance is. And so here we are just suggesting that phrases like render reasonable assistance ought also to be defined because it's not clear what that is. And just a little further down in the bill at line 104, there's another phrase, acting in good faith and also in a timely manner. And I guess our question for this potential issue is who decides that? Because again, this is a situation in this proposed legislation where someone would avoid civil and criminal liability because they have acted in good faith and made in a timely manner. And we're all for that kind of immunity to play out. But if someone gets arrested, they've not been prevented from being subject to criminal liability. So we're wondering, is it the police officer? Is it the judge? Is it the DA? Who gets to decide when those immunity protections kick in? We'd love that they're there. We would just like it to be clear who gets to decide that fact. These phrases that I've just mentioned to you all, these kind of civil law type phrases that are showing up in this criminal bill, they're not essential elements of the crime of hazing. So I'm not trying to suggest that they have to be proven. They don't. They're not essential elements of the crime. But to the extent that these phrases are impacting the prosecution of the crime and the defense of the crime, because they are laid out as means by which hazing can be perpetrated, there may just need to be some heavy lift by way of litigation to sort out the language of this code section if you were to pass the bill as it's drafted today. I've said a lot, and if you have any questions, I'd be happy to stand for them, but otherwise, I will leave you to it.
Thank you, Ms. Guertin. Does anybody in the committee have any questions for Senator Hatchett?
I have a quick question, and I understand the intent of the bill completely. Just the lawyer in me and thinking of exceptions, loopholes, things that may end up being determined to be hazing. The way that I'm reading this, and I may not, and I think I'm reading it correctly, but a school activity includes athletic teams, and hazing can be if you require someone to perform or endure physical activity. I'm thinking of University of Georgia football, the swim team, getting up in the morning and having to work out. They are exempt? Okay. Okay, that was my concern. Thank you.
Question from Senator Kirkpatrick.
Thank you. I just wanted to be sure I understand what you were saying, because you were talking about failure to render reasonable assistance, but then further down in the bill, around line 108, and on down to the bottom of that page, it really does spell out the specific actions that someone would do about requesting emergency attention and so on. What am I missing?
Well, these are, I mean, as I read this, I know what you're talking about, and this idea that you're not subject to the liability. I'm at line 108. Because the person does these things, requests medical attention, it's not clear that you are limited to these three types of behaviors. It's not clear that it's just the definition of also a timely manner. There's no timeline laid out here, which I realize, there's common sense that gets applied every day to the application of our laws. I understand that completely. Our question is who's deciding that and from what vantage point? And are we limited only to these A, B, and C? Are these the only ways that someone can act in good faith to show that they have tried to render reasonable assistance, because these three that you pointed out, Senator Kirkpatrick, that run in lines 112 through 119, are separate from the rendering reasonable assistance language. It's frankly, to me, it's just not clear. That's all. And I don't know if we're limited or not, and if there are other ways that someone could act in good faith to try to, whether it's render aid or in this particular portion beginning at line 108 is specifically related to the alcohol or drug possession, which this is the particular section, the alcohol or drug possession ties back to that 1613.5 code section, because the same issue is handled there. And it's just handled slightly differently, and it may be that Legislative Council doesn't see any kind of conflict, and that could be fine. We're just wanted to bring it to your attention. That could be.
Any other questions for Ms. Guertin? All right, thank you.
Sure thing. Thank you.
That's everyone that signed up to be heard on the bill. What's the pleasure of the committee? Do we have any motions from the committee?
I'm going to do pass.
All right. Well, you don't have to. We have a motion to pass Senate Bill 378 by Senator Hatchett. Do we have a second? We have a second from Senator Watson. Are there any amendments? Any discussion on the bill? All right, I have a motion to pass. All those in favor of the motion, please raise your hand. It is 5. Motion carries. Thank you. Pause for 1 sec. Next bill on the agenda is Senate Bill 471, Senator Robertson. Okay. And we are working off of a substitute, LC 442003S.
Yes, sir.
All right, Senator Robertson, the floor is yours.
Thank you, Mr. Chairman. It's always a pleasure to come in and speak to you and your committee members. I don't know if that says anything about me or not, but this is, again, as we say many times in this building, a simple piece of legislation. What we are attempting to do with Senate Bill 471 is take an archaic procedure that we have practiced in our 159 counties for years and try to add a little technology to it that will, I think, not only improve the results from these attempts by attorneys and other groups dealing with tax levies and foreclosures and other things, to not only get a much more reasonable return, but also to make the process not as labor intensive as it has been for the sheriff's offices and also for the attorneys that deal with these foreclosures and these asset surrenders based on actions taken by the court. And so what we've attempted to do is, as you can see, the strikes in 442003S at line 14, we have taken out this language that is extremely outdated on the first Tuesday of each month between the hours of 10 a.m. and 4 p.m. And basically, on line 20, you'll see the change there where it says such date at such time as provided for by the order of a judge of the Superior Court of the county. And therefore, makes it much more fluid. It doesn't touch anything to do with the sales, how often the sales occurs. Of course, that's based on actions within the courts, but also doesn't touch on fees or anything of that nature. And probably the important part of it is if you look at line 22, it says sales of property taken under execution as provided for in paragraph 1 of this subsection may also be conducted through internet, and I want to emphasize may also be conducted through internet-enabled technology and digital media, including but not limited to websites, consumer applications accessible through computers, smartphones, and other electronic devices. So what we've done here is we've actually taken these sales, moved them from, if the county so chooses, from the courthouse steps onto the internet, and or in the place and time as determined by the judge who is presiding over the particular action. And with that, I would, and we do have support of the Georgia Sheriff Association, and we've spoken to those involved with attorneys, and they see this as an opportunity to help them kind of expedite these things, and they can track these cases through their office. And the benefit of opening the sales up to a wider audience, I think, benefits everyone. And with that, I would ask for the consideration of you, Mr. Chairman, and the committee in SB 471.
So section 1, does this cover five-phase sales, like a sale where there's an execution on a judgment?
Yes, sir.
And so it doesn't cover the foreclosure sales people think about every month, the courthouse steps for real property. That's not covered in this
No,
bill at all.
I believe the code section covered, this primarily would be the sales under tax levies and executions. I believe foreclosure sales
Or separate.
Set aside. What we've done on these is we have sold real property on the courthouse step because of property tax issues and things of that nature and claims.
But section 2 is tax sales where outstanding taxes are
Correct.
over. Section 1, and I think is the five-phase, right, where you have a civil judgment and
Correct.
you have a sheriff executing that. Is that your understanding?
In section 1, yes,
Okay.
sir.
And so who makes, you mentioned that because you have the word may on line 23 and again on line 53, who's going to actually make that decision? Is it the local tax commissioner or sheriff making that decision, or is it something a judge would approve as far as the manner of doing the online sales?
I think currently that responsibility would probably have to rest with the court. I think as far as technology goes, it would have to be it's a great question, and I think it opens it up to the local to determine what they can do. Of course, they would have to have internet, they would have to have broadband, things of that nature. The putting of the information up on the internet, a lot of times that rests with the sheriff's office and those types of sales and other type of asset sales that law enforcement agencies conduct around the state. But the courts are the ultimate deciders on any of these sales, and that's the reason the time and place was given to the Superior Court judge.
Yeah, that's my question, because the time and place is obviously in the bill. That is at discretion of a judge ordering that.
Right.
But it's not clear just in the bill who would make the decision whether or not to do the online sales. And I don't know if that's important, because you may have some places where internet is not obviously there yet in parts of Georgia. And it may be that somebody wants to do online sales, somebody may not want that. I don't know who's actually going to make that decision. Do you have any, what do you have in mind as far as your intent as to who would make that decision?
Well, in the counties that do not have the ability to do it, then I see it continuing being a courthouse steps type sale. But to those who wanted to do it, currently the two primary individuals engaged in these sales are the tax commissioner and the sheriff.
Okay.
And it's in the county and where we conducted these, that was a great relationship. And so it was, as long as the check went to the tax commissioner's office, she was not concerned with the conduct of the sale.
Right. You have another question, Senator Kirkpatrick?
Yeah, just on the internet-enabled technology, is that presumably that's a third party, some kind of outside entity that's not under the control of the sheriff or the tax commissioner? So I'm just wondering about fees that might be associated with that and how that would work.
That would, now, you're talking about a third party is where they would have to reach out and enter into some kind of agreement with a third party to host these sales.
Right, unless they could do it internally, which I doubt.
Well, we have done them internally in some cases, but if they did open it up to a third party, then the fees would be negotiated in the RFP between the municipality and who the third party would be. If any fees, currently all fees are on to the individual who purchases, are required as any other auction, if you will. The buyer carries the burden of all fees associated with the purchase.
Any other questions for Senator Robertson? Senator Hatchett?
Just for clarity, this would also apply to foreclosed on houses. Is that correct?
I think something the chairman alluded to, if you'll give me 1 second.
It's my understanding that's
It's-
entitled 44.
Yeah, this would only apply to those five-phase sales.
Okay.
But it would be a five-phase sale, which I guess would, as a tax sale, could include real property, would include
Oh,
real
no,
property.
five-phase sales do, and yeah, they, in many cases, include real property.
But
Yes.
a power of a sale and a mortgage is governed through Title 44, and it's not impacted by the changes here. Am I right on that, Legislative Council? Okay.
Yeah.
Ben?
The foreclosure sale is handled under Title 44. It's 44-16-121.
All right. Thank you. Does that answer your question?
It does, and I think my only hesitation is, in rural areas that I represent, sometimes families can pull together their resources and try to buy back property that may have been lost from a loved one, a grandfather, or something like that. And I have a little bit of pause because I understand free market, but I also understand, the resources in a rural area aren't quite as vast as they are across the country. And if you were to open up, just for example, in Habersham County, Georgia, if someone's trying to go buy their grandfather's house back and keep it in the family, and you open it up to bidders all across the country, how that would impact, I guess, the local economy and the community there.
And it would not only just around the country, it would open up to bidders around the world.
Right.
And as much as, I think sadly, law doesn't leave a lot of room for emotion. And I think to level the playing field and to move forward with this process, I've held these sales on the steps of the courthouse, and two people show up, and they are there for the same piece of property. In other words, it's the person that wants the property and the individual with the checkbook. In some cases, it's extremely unfair in the other direction, if you will, to where we may be looking at a tax levy and somebody comes in and is able to purchase a piece of property well below what the property is worth and walk away with it.
Yeah.
Are you familiar with the process of the notice that's given to the property owner for a tax sale in particular, and the ability to recoup the property within so many days?
I know that there are mechanisms within the system to where the original, the individual who actually owes the taxes on the property, they are given multiple opportunities to maintain the property. But it's not as simple. Levying on someone's property is not as simple as it may sound. In other words, a lot of hoops have been jumped through, and a lot of processes have occurred in the court before we're at a five-phase sale. And we foreclosed on many properties in Muskogee County where they had to be sold, in property and inventory, and where individuals were given multiple opportunities to make things right, to the point of even, trying to go and work out situations with financial institutions to support them, and that we've always given them as much latitude as the law allows.
Any other questions from the committee? All right, we have one person silent to speak on the bill. Buddy Ramsey with Investa Services.
Thank you, Senator.
Good afternoon.
Good afternoon. Thank you for having me. I have three major points of concern that I'd like to bring to the attention of the committee. The first one is in the new redraft, the deletion of the tax sales and or the sheriff sales on judgment levy not occurring on the first Tuesday of every month is something I just saw today. It kind of took me aback because this is something that's been in there, as Senator Roberts says, maybe somewhat archaic and whatnot. But I do think it's important that we have a provision that at least requires at some time during a month that a sale occur. And currently, and if this bill is currently drafted, I don't read that it requires the judge to, quite frankly, ever set a sale. But I think that having a monthly sale is a necessity in the community of investors that I deal with. The second point that I would like to raise really takes a step forward, Senator Hatchett, on your comment a moment ago. Our system of tax sales is somewhat, it's somewhat nonsensical in that a taxpayer is more often than not benefited by a lower price being paid for their property on the steps, because the redemption that is required to be paid is what is ever paid for the parcel at the tax sale, whatever someone like me would go in and buy that tax parcel for, plus a 20% penalty based upon that amount. So if your house is sold for $1,000, you can redeem it from me. Mom and Pop, the community can get together and redeem it from me for the $1,000 plus $200. If I bought it for $100,000, you would have to redeem it from me for $120,000. It's the way our tax deed system is set up, and it is somewhat nonsensical, but to encourage participation in our sales by foreign investors, I don't think at the end of the day is necessarily beneficial to the very people you were talking about, Senator. The third item that I'd like to bring to the attention of the committee, I know Senator Roberts indicated that there was no change in the fee structure. And based upon his answers to some of your questions, I think he was concentrating on a situation wherein the sheriff's office itself might be conducting the internet sale. Senator Kirkpatrick, you asked about if a third party were to come in. Third parties conduct these sales throughout the country. I participate in a lot of their sales around the country. That's and I am concerned that there is no discussion or provision for whatever fee would be charged by that party. I will say this, that the tax collection process is like a funnel. You start out with the entire digest. Some of it pays on time, some of it doesn't. That part that doesn't gets levied upon. That levy process takes 90 days plus while the sheriff and the sheriff's staff are providing notices and publications and whatnot to the taxpayers and parties of interest. That causes that portion of delinquencies to come down substantially, usually 50 to 90% of what starts in the levy doesn't actually go to the steps. I would suggest that it would be inappropriate for a third party to charge fees associated with whatever started in the levy as opposed to what actually went to the steps. In other words, if you started with 100 delinquent parcels and then the internet sale only resulted in the sale of 10 parcels, to charge that fee on all 100 parcels, it's not a fee that would be placed upon me as the purchaser. It's a fee that would have to be paid by the taxpayer to redeem his property and pull it out of levy. And I don't think that that's what is the intent of this legislation, but I see it as a a practice that is engaged in by internet providers around the country, and I would be concerned that that issue be addressed if this legislation were to go forward.
All right, thank you, Mr. Ramsey. Any questions for him? All right, thank you.
Thank you.
Senator Robertson, if you could come back up. I have concerns about who's going to make these decisions, and maybe some communities may want to do this online, but some may not. And I think Senator Hatchett brings up a good point maybe we want to address is what about the idea that it's better to have it where just locals are going physically and bidding on this versus having the competition from international folks, as you said, that could drive up the price, knowing that I guess the only person that would benefit from a price going higher is the person buying. You have any thoughts on that?
Well, I do, and the gentleman, and if it's okay, I'd like to ask Terry Norris if he could with
Sure.
Georgia Sheriff's Association come sit down. But on the purchase of levies, in which he was talking about, where the percentage is added, and you go in the purchase of levy, that would lean more toward Senator Hatchett's concern. If grandfather fell behind and somebody came up and bought that, there's a time period in which the family could still get the money up and purchase the property back from the individual who purchased it there on the courthouse steps. And talking to Terry Norris, I think he said he believes that was 24 months that they would have to do that. As far as, again, the competitive nature of the internet, I think that's the reality of the world we live in. And in today's world, or excuse me, in today with these sales, the primary decision maker as far as putting it online or keeping it the way it is rests in the sheriff's office today. We've conducted these sales, similar sales, where we would sell seized assets from drug dealers. We would wait and do it, and we'd have 40 cars and multiple households of whatever, and we would contract with a third party to come and conduct these sales. They conducted them in person, and at times they would conduct them online, and we would put an RFP out to give everybody an opportunity to come in and offer the best service and the lowest fees, and whoever succeeded in the RFP process, that's who we would use, and the purchaser would be responsible for paying for those fees. It's I'm always a little surprised, I guess I shouldn't be, when we start talking about fair, which we're talking about money, and individuals owe things or individuals sell things. All the conditions are very much in front of all of us. And while I appreciate the gentleman being concerned that foreign investor may come in and buy a property, our laws allow that, and it's the reality of the world we live in, and foreign investors are throughout our country and our state as we are in other countries, and so I feel that's just part of it. But the mechanics part of it, and I think something that Terry can speak to, is that these sales, 80% of the responsibility rests solely on the shoulders of the sheriff executing the orders coming from the courts.
Mr. Norris, do you have anything you want to add?
Well, yes, sir. I think it'll be from the perspective of the sheriff as far as who determines whether they'd be an online sale. I believe that would fall under the responsibility of the sheriff, as it does now. I've talked to a couple of sheriffs about this, and on real property, there's been times where sheriffs would have to arrange a wrecker to bring something to the courthouse. So I see this arrangement of determining whether that's an online sale to be similar to that. The sheriff is still arranging for that to occur. And it is permissive, as we have seen in the bill. So I do think there are places in the state that won't do online sales. But I think if it were to help and there's the ability to do that, I think the sheriffs would grasp that opportunity.
Good question, Senator Hatchett.
Thank you for that explanation. So I guess if my understanding is correct, it would be on a sale-by-sale basis that the sheriff would have the discretion to determine whether or not it would be online or in person based on the item or the property that's being seized. It wouldn't be a blanket, well, this county, we always go online sales.
That would be my presumption.
Okay.
Senator Kirkpatrick.
Sorry. My question is that if, let's say it's a family and they are able to redeem the liability, then would they be dealing with the sheriff's office, or would they be dealing directly with the internet provider?
It'd be dealing with the purchaser. They would be dealing with whoever purchased their property, purchased the debt on their property. So the individual who purchased it, either from the courthouse steps or via internet, I think what we alluded to at the beginning, I think is what you're referring to, they would be dealing with, and that person is obligated within those 2 years to, accept that plus the percentage uptick.
Do you have any information about who's currently attending these sales and whether or not we do have a shortage of potential buyers as well? Is that the issue? Is it more just logistics of conducting the sale?
Well, from our perspective, changing the first Tuesday and the time will be greatly assist the public. Because Tuesday from 10 to 4, whatever it was, is not convenient to the public. So
Yeah.
I think you'll have greater access to the public to that part of it, as well as the online purchases.
Okay. Any other questions from the committee for Mr. Norris or Senator Robertson? All right. Let's hold on the bill to get some answers to some of these questions we have. And it may be helpful if you want to even have Senate Research share with the committee a little bit more information about this process, since we only see a small glimpse of it in a bill, so we can understand how it all works too.
And I think I'll work more with Mr. Norris, and possibly we'll just designate as the decision to be made by the sheriff of the county.
I know that
As to
would make
whether
me
he
more
or she-
comfortable. That way you
Yeah.
could have a decision by an elected official, county by county, but also keep in mind, if it's a tax commissioner that's doing it in some counties, I don't know if that would go whoever's conducting it will make that decision, but let's dive a little bit
That's
into
right.
that too.
Yep.
Okay.
Thank you.
Thank you.
Thank you, Terry.
All right. We have 2 other bills from Senator Robertson. It's his show tonight. The next one is Senate Bill 380. And we are working off LC 490687.
Yes, sir.
And you have someone join you up here?
I do.
All right.
I'm Claudine Wilkins.
What was your first name?
Claudine Wilkins.
Claudine Wilkins. Welcome, Ms. Wilkins. All right. Senator, the floor is yours.
Okay, this is, again, really simple as we start. What I'm attempting to do here is I'm attempting to remove the free bite away from aggressive animals. Currently in the state of Georgia, the law says that an animal's allowed to get away with a free bite. There was a young man in my office, or his father was in my office a few months back, along with Claudine, and we were sitting there, and this father was showing me pictures of his son, his small son, who he was out walking with one day here in Atlanta, and these 2 very large dogs came around the corner, and the father lifted his son up but just as a reactionary move, and rightly so. These dogs were extremely aggressive, and they attacked the father. And one of the dogs was able to grab the father from behind and pull him to the ground, where the other dog was able to partially pull his son's scalp away from his skull. And the father screaming for help as much as he could get while he was attempting to fight one of the dogs. When the dogs were finally ran off, the little boy was taken to the hospital and his scalp was reattached. And he now goes to school, and I think he's around 3 years old, and he wears a hat at school because he has this huge keloid of a scar on his head. And it's not that the kids make fun of him, but they ask what it is. And once help did show up, that the owner of the dog refused to claim ownership of the animal. She was living in a rental house and was caring for and managing these two animals, but she attempted to make it sound as if she was taking care of them for somebody else. When the neighbors you spoke to, you realized that these were in fact her dogs, and she worked at night, and she would come in and basically allow the dogs to run through the neighborhood during the day. And while working on this, I was speaking to a member of my delegation out of Troup County, and he was relaying to me that a few weeks back, as he was out walking, a German Shepherd ran out there and basically ripped his pants half off of him in an attempt to assault him. And he told the dog owner that the next time the dog came after him, he would shoot and kill his dog there in the street. And allowing these animals to just run amok and have their free bite leads to these types of conflicts, escalates, I think, into a problem. And as a father of a 3-year-old child, I can't say that I hate to think what I would do, because I know exactly what I would do if my daughter were exposed to this kind of treatment. And what this bill does is it holds owners accountable, and it holds, if I choose to allow Chairman Strickland to manage my wife's dachshund while we're out of town, and Oscar should all of a sudden become violent and go out and assault people, then Chairman Strickland has failed to fulfill his obligation of managing our dog while it was in his care. And I've spoken to the trial attorneys and spoken to others who have some concerns as far as if the bill is written extremely strict. But I think at some point we have to take the physical and mental well-being of people who want to be able to go out and enjoy their communities. We have to place that above some of these other concerns. And I think that this bill does by, you'll see on line 14, we're adding the harbors in there. Of course, you saw we struck the vicious and dangerous out. And if you move over to line 23, in any action brought pursuant to this code section, provocation shall be a defense to the extent that it caused the incident to occur. The person who owned, harbored, or kept the animal shall have the burden of proving that the injured party provoked the animal. So what I'm not trying to do is just give free rein for people to go around and harass animals, because our dog parks are growing throughout the state of Georgia. I was in a rural part of my county the other day, and they have a dog park now, and a lot of people were using it. And so if anybody goes out there and attempts to provoke one of these animals, these are animals. As much as we like to think that they're our babies and our furry sons and daughters, they are animals, and they have instincts that never, ever leave them. And so once we take on the responsibility of taking one of these home with us and saying we're going to care for it, then we take on the responsibility that comes when we fail there and allow it to go out. And assault 3-year-old kids. If you look at line 28, the person who owned, harbored, or kept an animal that has injured another person shall provide upon request insurance information to the injured person or his or her agents, i.e. attorneys and others involved, because this lady here in Atlanta just refused to take any responsibility for the absolute damage that her animals caused this child. And for that, I will stand for any questions. And I have an extremely well-versed, I'll call her an advocate and attorney who has dealt with these animal issues for a long period of time.
Thank you, Senator. Historically, Georgia has passed laws when tragedy strikes. In 1989, a little 10-year-old boy was killed. We changed the dangerous dog law. In 2007, a little girl named Mercedes in DeKalb County was injured, almost killed. We changed the law again. And in 2009, Cheyenne Peppers, a little girl in South Georgia, was killed, and we changed the law again. And that was the dangerous dog law. And Representative Gene Maddox spearheaded that, and I helped him draft that. One thing I asked him to do was to change the name of that law to the Responsible Dog Owner Act, because that's where the liability really lies, not with the dogs, it's with the owners. My career started off as a prosecutor, but for 30 years now I've been training judges, prosecutors, law enforcement on all of these type of cases related to animal laws and dangerous dogs. And the feedback over these many years is that they really don't understand the law because of the way it's written. It's very hard to hold somebody accountable because roughly 30% of our counties do not have any animal ordinances whatsoever. And the way our law is written, it says that the only way you can overcome this duty to prove knowledge that the person knew or should have known their dog was vicious or dangerous is to show that they violated a local ordinance. But if our counties don't have those ordinances, then victims are treated differently. This is a perfect example. This little boy and this little girl were in different counties of Georgia, and it almost happened within the same year. And the facts are very similar. Two very large dogs almost killed these two children. Yet one of these cases was not ever given anything but a fine, and the other one went to court and was treated differently. So one of the things I think Georgians should have is the same remedy that any Georgian would have anywhere in the state. So that's one thing we want to correct. Also, since January of this year, January 1st, I've talked to 10 separate victims. Of them, 9 of them I had to tell them there is no remedy for you because we can't get the owner to admit that they knew or should have known their animal was dangerous. We can't get their family members to admit. And by the way, 76% of the prior bite is usually within the family. So we're pitting family members against each other, neighbors and friends, to say, oh yeah, I'm going to rat out my friend who's the dog owner in this case by being the one that's going to finally tell somebody that there was a prior incident. Another thing too is those prior incidences are sometimes only recorded in a local jurisdiction. So it's not like we can do a GCIC check and find out if there's a prior incident. So we rely on family members telling on other family members to find out if there was any prior knowledge. Also, the other thing we find is that when we pull somebody over for a motor vehicle accident, it says on the report, you ask for insurance information. That is rarely discussed or even given in a report bite. And so the victim is then left to call the dog owner, who may never speak to them again, and then they have to go on and find an attorney to take their case. And attorneys, as you all may know, personal injury attorneys don't like to take cases that they don't know if there's any insurance. So they're left in this limbo state of finding out whether or not there's insurance or not. So just simply asking for those pieces of information is important for the report, specifically rabies and following a rabies protocol, because there are cases where rabies were not checked, and if there is an exposure and they fail to get it, rabies is 99.something% fatal. So there's a lot of things that need to be fixed within this law. I'm happy to work with Senator Robertson as well as Lieutenant Governor's office on getting the right language for this bill, but it's certainly something that needs to happen because for 30 years I've seen too many problems going on with remedies for children especially, and children are the number one victim. Second in line are meter readers and delivery people, and third in line is the elderly. And one other thing, provocation is on the burden of the victim. And there's case after case where the victim has amnesia due to the severity of the attack. The Braden Kelly case in particular in Cherokee County, he could not remember what happened to him before the attack. So he could not prove whether he provoked the animal or not. So most states follow a strict liability rule. 37 states, in fact, follow some quasi-strict liability or sheer strict liability. So we're somewhat behind the track compared to other states. And for public policy, they're following new rules instead of the common law negligence rules. That's it.
All right, you have some questions in the committee. Senator Parent.
Thank you. Thanks so much for being with us, and thank you, Chairman Robertson. So I just wanted to walk through the scenario a little bit to make sure I really understood. So currently, so I'm a DeKalb County resident. Mm-hmm. So currently in DeKalb, there is an ordinance. Obviously, there's also leash laws, right. Or keep your animal fenced in or what have you, and. So so I'm assuming that there would be certain breeds that would currently fall under this vicious propensity?
No.
No,
In fact,
because we got rid of that, the breed specific.
well, there's no getting rid of it. There was never a breed specific.
Okay.
What it is our appellate courts have said that just being a certain breed does not determine that you're a vicious animal. So
Okay, so it would
is-
have to be per the dog.
It's just dog, right?
Or any other animal, because this
Right.
applies to any type of vicious animal, I
Right.
guess. So if I had, right now, my Cavalier, King Charles, ran out and he's never done anything before, but tomorrow he gets out and he bites a child, I would not be liable, but under this, I would be?
Yes, you could still be liable, absolutely, because your dog is at large.
So what would that was another question I had, is like,
Which an at-large dog would be a violation, an ordinance violation
Right.
in your county.
yes.
Yes, ma'am.
And so whatever penalties come with that locally, I would
That's a
already
criminal.
be.
That's a criminal violation. But the dog bite statute, which is a civil remedy for the victim, they could show that you violated that local ordinance. Okay, and then it becomes somewhat of a strict liability issue. So yes, you would be liable for that. But in a county where they don't have that, then that victim doesn't have that same opportunity at all.
So in this, it would eliminate the whole question of whether the owner could have known or had knowledge
Correct.
that the animal was vicious,
Right.
and you would just be liable.
Right.
And the provocation piece, you are saying that it is strict liability in certain states or areas, but it still wouldn't be here under this. We would have a provocatory.
Provocation is separate from the remedy of proving what you have to prove. Provocation is on the burden currently of the victim. Okay, so provocation, for example, you can't say that, well, if somebody's committing a tort or willful trespass, they can't claim an injury under the dangerous dog law or this civil dog bite statute. They have no remedy whatsoever if they're committing a tort or violating some trespass issue or anything like that.
I see.
Yeah.
So I could raise that as a dog owner.
Correct, absolutely.
if
Yeah, you
somebody
have a lot of remedies as a dog owner, for sure. The one thing to understand about provocation is most states recognize that proving provocation is upon the shoulders of the dog owner, because in some cases, people don't remember what happened prior to the attack. If it's a severe attack, they have amnesia or what have you.
Well,
And-
really, someone. I mean, unless the person attacked can remember it, it would really rely probably on eyewitness.
Eyewitnesses?
Yeah, eyewitness
Correct.
testimony. So in this instance, what is the what sorts of penalties would I be looking at under this for my attacking dog?
So this is a civil dog bite statute, not criminal. Criminal is the dangerous dog law, which is now known as the Responsible Dog Owner Act. And there could be a fine imposed in that law. But this is the civil dog bite statute, which allows for a remedy of the following things: a victim's medical expenses, a victim's future expenses. For example, this little boy that was injured, Nick, he will have a lifetime of problems. He has not yet entered school. He will be bullied, most likely. As attorneys, we have a book that will tell us if an African-American male with a scar on his face, he's less likely to get all these type of jobs, and his income will be different than the average person. So there's a lifetime of problems this young man has to face. So he has the right to ask for that as a remedy for damages.
So like a victim-centered remedy.
Correct.
Okay, thank you.
Which currently doesn't exist based on current law, which allows since this is the only documented first bite, as documented as it is.
And just let me say, some first bites end in fatalities. And if we don't incentivize dog owners to understand that and to protect the people, then harm is, we have to protect people against harm. And what incentivizes a dog owner to be responsible is to know that there could be a penalty.
You have other questions? Senator Kennedy?
Mr. Chairman, 15, please. So, thank you, ma'am, for being here. And I want to thank Senator Robertson for bringing this. He's a man with a big and sincere heart, and I know that's what's driving this. But I've got some concerns about this being a landscape shift. What I think, to me, seems to be a landscape shift in the liability landscape for something like this. And I think Senator Parent really sort of asked very similar to the question I have at the core of this, and so I'll ask it my way to make sure. So we're currently keeping my daughter's dog. We call her Wilhelmina. She is an Irish cream golden retriever, absolute cream puff. She's about 3 years old. She has trouble biting a biscuit. She's never exhibited any propensity, any vicious nature at all. And I think I'm reading this bill to say, if Willa bites somebody, although she's never bitten anybody or anything before, then I'm going to be legally responsible, even though, of course, I wouldn't want my daughter to have to stand in my shoes for that, but it would be my daughter as the owner or me as the keeper of the dog, whatever the phraseology is, the person, I'm harboring the dog. So that's my first question. Is that right? Am I going to be responsible for the first time Willa bites someone or engages with someone in a harmful way, even if I weren't there to see it? And if I'm not there to see it, I'm not going to be in a position to argue that someone provoked her, right? Because I would think a lot of these cases involved only the dog and the victim. The owner's not around, maybe. So under that fact scenario, am I now legally responsible for Willa's bite?
I think in your situation, Chairman Kennedy, that you would be a responsible harborer of your dog's pet, and the dog would be either locked inside your fence at home or it would be inside your house when you weren't there with the dog. What this focuses on are irresponsible pet owners and those who are caring for pets who allow them to go out unsupervised and create these types of problems. The vast majority of Georgians who own dogs, cats, and everything else are responsible, loving owners. This right here focuses on that small group that are not as responsible as you are.
Well, I
And
appreciate.
so
I'm sorry.
what I'm saying is, yes, if you are irresponsible with your dog sitting and you allow this animal to go out and hurt someone, yes, you would be liable.
And
So,
you could be
and I-
liable right now under the current law, too.
I'm what? I'm sorry?
You could still be liable under the current law as it is, depending on where you live. So if you have careless management of your dog, even though it's not aggressive, you could still be liable. And
Based on ordinances?
Yes.
Okay, so assume I live in an area, which I do, which doesn't have ordinances. And I appreciate Senator Robertson's answer to the question, but my concern is, notwithstanding that answer, I think I am looped into all of this. And the short answer to my question I'm hearing from both of you is yes, I'm legally responsible for Willa's first bite. And she's never exhibited any problems, number one. Number two, I live in a neighborhood where you're supposed to keep your dogs inside your yard, and we do. We have an electric fence, but batteries die, electric service goes out, things that can happen. And so now Willa's out, and she's never done this before. If she bites a dog, and I bite someone, and I'm responsible. The answer to the question is yes under this, correct?
Well, under current law, I believe you are also, and I don't know, you're in rural county,
Yeah.
I assume.
Yeah.
So I don't know if you'll have animal control or whatever on the rural side, but yes, sir. If you know,
It's
But
foreseeable.
here's what I'm struggling with.
Yeah.
Where's my negligence? Where have I done something wrong? Where have I failed? Where have I not protected someone else? Because, and you used the word, and I was going to ask you, what this bill really does, it's strict liability. And the trouble I'm having with it, Senator Robertson, because I know your intent for this, and it's honorable. But as you talked about it, animals are animals. Animals do things that aren't predictable. Dogs do things that aren't predictable. Even sweet little cream puffs do things. And if I'm not on notice that she had ever had a propensity like that, I'm struggling with why I should be responsible when I should be legally liable when I have otherwise been, in my example, 100% responsible as the owner or the caretaker of the dog. And notwithstanding assumed perfect responsibility on my part, I wind up on the legal hook for that. That's helped me understand why that's fair.
well, and from a criminal justice side, you know, it's hard for me not to go back and look at a motor vehicle accident and say that the driver of vehicle number one has always been a responsible driver, but accidents happen. And when that accident occurs, it's not that the individual is a bad driver. It's just at that point they failed. They were irresponsible.
But there's an element of negligence there. And in my example, go back to my example, there's no negligence on my part.
Well,
so it's not analogous to, all due respect, it's not analogous to a motor vehicle accident because there's some negligence involved for someone to be found the at-fault party. In my example, I've done nothing wrong. Will has done nothing wrong, right, to put me on notice. So where, that's the issue. Help me understand that.
Okay.
Yep.
Yes, I'm happy to. So the fact that your dog is at large, because you said the fence didn't work, the batteries died, there's a foreseeability that if he's at large, he's uncontrolled and there's careless management. Even though you don't know if he's vicious in the past or not, there's still the element of a foreseeability that dog could cause an accident, scare somebody, and we have 2 cases in Georgia where the dog never touched someone. They simply ran after somebody who was afraid of dogs. They ran into the street on separate occasions and they both got killed by cars. But that was a foreseeable risk. Your dog being at large because you failed to put the batteries in or didn't update the batteries, I'm sure a really good personal injury attorney could find out that your failure to make sure your fence was operating properly is the foreseeable risk.
But but
Okay.
the problem is you've skipped over the issue of I'm not on notice that the dog has any propensity to bite. That's the landscape shift going on here.
Right.
That's where, and if I were, I'd agree with you. If she'd ever bitten anything or anybody before, I'd agree with you. I'm on notice that I don't have the cream puff. I've got a dog, even though she may look like a cream puff, I now know she might not be. But as I sit here today, and in my example, I had no notice that she might be.
So let me ask you this question, if I may.
Okay.
Let's say your dog, Cream Puff, did get out and bit somebody or caused somebody to run into a tree, and that person is now disabled or maimed for life. What do they do about that? Where's their remedy at law?
You're asking me to pay for that for something that I wasn't negligent in any way. So your question, you're trying to shift that cost, that societal cost, that burden to me, but you're skipping over the question of where was I at fault? What did I do that was wrong?
Senator, I think when I touched on a few minutes ago talking about an animal as an animal, I think we have to understand when we go to the pet store or the breeder or wherever we go to purchase our animals, we're purchasing an animal. There's a risk inside that creature that we don't fully understand. There is a DNA fiber being there that they are not built to be maintained by human beings naturally. The most aggressive dog I ever had was a 5-pound, no body fat Chihuahua named Catfish. And I knew that Catfish didn't like people. So when people came over to visit me, Catfish went to the crate because I didn't blame him for being that way. I was being a responsible owner because he is an aggressive animal. Our problem is we start confusing animals with human beings. We start thinking that they think like we do and they act like we do, but they don't. I've had people tell me I can provoke an animal, certain animals I can provoke just by staring at them. We do not understand their mindset. Therefore, what we're trying to do is emphasize to the nth degree the responsibility of owning an animal.
And I agree with you, and
right.
I'm with you, and I agree with you. But the problem is you're not addressing my issue, which I am 100%.
Your issue.
No, in my example.
Yes, sir.
I am 100% responsible.
Correct.
I am 100% prudent. I am 100%. I did all the right things. My daughter did all the right things. But yet you're shifting the liability to me solely because I'm the owner, and that's. I'm just letting you know where I am.
Yes, sir. But you also failed to maintain the electric fence.
No. What if the person comes in my yard?
No. Then if they trespass into your yard, then this doesn't apply.
Where's that?
It's line 15.
Okay.
I think the current law has careless management or by allowing the animal to go at liberty. So there is that element that is
That's
still
already in the law.
In the law.
One of our
Okay.
judges appellate judge, Judge Ruffin wrote, "A dog should have no greater right to a first bite than one has to a first murder. And as between the dog owner and the blameless victim, the owner is almost certainly in a better position to judge the dog's proclivity to bite. Yet under the first bite paradigm, one may be subjected to, without the recourse, to an animal's first attack, and that animal's owner has little incentive to guard against the potentially deadly event. So that was one of our own judges here writing that in a case. It's certainly time for a change. I understand where you're coming from, Senator, I do. And I'm actually working with Lieutenant Governor's office on some language. But we have to see that other states have done it. 37 have already done it, including District of Columbia. So public policy has shifted, and we should go along with that. The main thing we've got a problem with is the fact that some counties don't offer these ordinances. And so why should a victim in that county not have the same remedy in a different county?
Can I ask one follow-up, Mr. Chairman? In those states where they have moved in this direction, do you have any experience with regard to how the insurance industry has responded? For example, are they now writing exclusionary language so that for your pet, regardless of whether it's a goldfish or a Rottweiler,
That's already happening.
we're not, there's not going to be coverage for it? Because if that's the case, that's going to be substantially discouraging. I don't know who's going to want a cream puff named Willa if their insurance company is going to say, sorry, you don't have coverage.
Until I see an actual actuary analysis of the insurance numbers, I will tell you that New York just passed a law that says you cannot list a breed discrimination in exclude dogs. In Georgia, there's just recently I got a policy that said we will not cover any of these dogs, and we will not cover a dog that has a prior history, which is going right against our law. So if we have insurance companies bailing out on homeowners for no coverage, then what do we end up doing? The taxpayers end up paying for these children like Nick, who's never going to look the same, and have at least a few $1 million worth of medicals already. So time for a change, I think.
Thank you, Mr. Chairman, and thank y'all
you,
for
Chairman. I appreciate
thank you
that.
for the earnest discussion on this. I appreciate that. Thank you.
Senator Hatchett.
Thank you. I have 3 questions about the bill. Number one, I think may have been addressed from Senator Kennedy earlier about having a dog on your own property, and I have to think of an example. My nephew, my brother, had a dog that was a golden basset. If you've ever heard, it's like a basset hound golden retriever. It looked like a golden retriever if it was sitting in the truck, and then he jumps out and it's like this tall. But anyway.
Do you want to share the dog's name?
Champ, I believe.
Thank you.
But anyway, sweetest dog ever. But the dog ended up, when my nephew was 2, attacking my nephew. And the dog had never shown any vicious propensities before. We don't know what happened or what provoked him. My nephew's fine now, but in those instances where you're at your house, you have a dog that's never been vicious. I'm I'm thinking right now how you would prevent or encourage kids to play with dogs, or why you would have a dog if you had this strict liability right there. And I understand the intent of Senator Robertson, especially in a dog park or when you're out in public, but in the confines of your own home, how do you, with strict liability, is that the policy that we want to push here?
Well, to me, and it goes back to a responsible dog owner, and I understand this was an anomaly. This dog, for some reason, some unknown reason, attacked somebody, and that's the reality and the liability of being a pet owner. And that's the importance of homeowners insurance and other things that go along with that. I think we can come up, and this is a real situation that occurred, and I've heard of others where they've had dogs in the house and the dogs have always been fine, and then the mother's doing something in the other part of the house and she comes and her infant is being practically decapitated by a dog in the house. And the mother lives with the fact, knowing that while she was caring for another child, another one of her children were killed by a dog. That was a family pet, if you will. And I understand, as strict and harsh as this sounds, you know, at some point we have to put down a bright line when it comes to what being a responsible pet owner is. You know, I don't own a dog. My wife has a dachshund that couldn't bite through a balloon if he tried. But I understand his personality, and he has a crate. And when a lot of people get in the house, they always like to touch him and all this other kind of stuff. And Oscar is grumpy like my wife's husband, so I take him and I put him up because I don't want him harassed. And like I said, he couldn't bite through a balloon, but that one time where he did bite somebody and break the skin and hurt him, I would feel responsible.
So in your scenario that you just gave, let's assume it was a tree limb that fell on your nephew and broke his back. I don't know. I'm just saying, it was a horrible incident. Your homeowner's insurance would cover that. So what difference would it make if it was a sweet, wonderful, loving dog who just didn't like the toy that your nephew was holding and it bit him profusely or once or twice? It doesn't matter. Why would that homeowner's insurance not cover that?
A lot of the homeowners policies that I've seen exclude strict liability.
Well, if you look at the way the law is written now, you could argue there is strict liability in it, as long as you are able to show that you violated a local ordinance or some careless management of your dog. It is somewhat of a strict liability.
Well, I just wanted to bring that one point up, and then I have two more points. They'll be brief, Mr. Chairman. I promise. Okay. Just things to consider. The burden shifting. I don't think there's another civil action where the burden would actually be on the defendant. I'm a little uncomfortable with that from a constitutional standpoint. I know on the
provocation.
Yes. Yeah, because that would be the crux of your argument there, and when you shift that away from the plaintiff who has the burden to prove their case to begin with, I think that may be an issue. And then the third burden is there are a lot of beekeepers in my area, and I just think that I'm sorry. That may be something that we should look at.
You had to let him go.
Are they Africanized bees?
Yeah. I was more worried about roosters being excluded. I don't know why you think roosters are different. But
That was
anyway.
already in the law.
That was already in the law.
All right. Senator Kennedy just has one more question.
Yeah, just one. And thanks for pointing out the difference of if someone comes on my property, but it raises the question, what if someone comes in my home as a guest and Will is an inside-outside dog? Same scenario before. You come into my home and you're bitten in my home. Is there legal liability there?
There currently is still legal liability for anyone. A dog attack can happen anywhere.
But no history. I don't live where there's ordinances, so under Georgia law now, there's not liability.
Well, it depends on how your ordinance is written.
No, I don't have ordinances.
Okay.
So I live out in the country.
Okay,
There are no ordinances. She's never never bitten anyone before, so there's not current Georgia liability. Agreed?
It depends. I mean, I need
Okay,
to know
well,
what you might have not done or did, because you could
With those simple examples, there's
Right.
not Georgia liability. So my question is, if this passes, Randy comes by to see me, he doesn't do anything to provoke her, but for some reason Will bites Randy for the first time.
Right.
Is there liability if that happens in my home
Yes.
under this bill? Okay, thank you.
And it could be under the current law too. I'm just saying.
All right.
If I ever get bit by a dog named Willow, I'm not reporting it.
Last question, Senator Rhett.
I was just wondering, thank you, Mr. Chairman, is there any way to maybe distinguish between the degree of bite or injury? Because I know I had a dog, his name was Silky, by the way. When he had enough, he would put his mouth on your hand and let you know, he wouldn't bite, but he would let you know, okay, I had enough. Is there any way, I guess I'm trying to say, a bite or a serious malicious injury? Is it any way maybe to...
Currently in the Responsible Dog Owner Act, there's two classifications, the dangerous dog and the vicious dog. And there is discussion about the severity of the bite. There's an actual definition of a severe attack. And if it's a severe attack, it bumps up to a vicious attack or vicious dog label. The focus on the civil dog bite statute is whatever the injury is given or received by the injured party, whether it's a puncture wound or decapitation, which has happened, it's just a civil remedy that allows that victim to pursue whatever their damages are.
It's because we've been around, I've seen some dog attacks, and it's not like, oh, well, I'm sorry, that's not gonna cut it. You probably wanna go get your shotgun or something. So I'm just trying to, that's the only reason I brought that up, is there's some way to distinguish, hey, maybe a bite is one thing, but malicious attack, that's a whole different.
If someone intentionally sicks their dog on someone, that's an assault.
Not
Yeah.
even that.
Yeah.
If the dog just, like he said.
Senator Redd, I think that determination would have to be made by somebody in Senator Kirkpatrick's profession as to the severity. If you went to an emergency room or something like that and had to get shots, stitches, things of that nature, would determine the severity of the injury. Yes, sir.
Because I support your efforts and what you're doing. I was just trying to.
The criminal law does have a classification to showing a severe versus not.
Well, Senator, you have a lot of trial lawyers in this bill with you. I know, looking at the sponsors here, I know you got a bunch of trial lawyers together and drafted this. But I do think, in all seriousness, there is an equity in the current law that you have pointed out. And it would be great if we could dive more into this and maybe look at what some other states have done versus, it's not really strict liability, but it's close, what you have here. Maybe peel this back a little bit without looking at such a big drastic shift in the current policy. I don't have the answer for you, but you're obviously well versed in this, and you know what 37 other states have done. So maybe y'all can bring us some other ideas.
Thank you,
to
Mr.
the
Chair.
committee.
I appreciate that opportunity.
All right, thank you.
Thank you.
All right, last little easy bill from Senator Robertson. Senate Bill 381.
I promise you my testimony will be shorter than my
Tax
opponent's.
sales, dog bites, pimping, and pandering, last one.
Okay.
So that's LC 490690. The floor is yours.
Thank you. Again, all I'm attempting to do in this bill is currently in Georgia law. The charges of pimping and pandering are misdemeanors, and I want to move them into felonies. 12,000 times a month in the state of Georgia, a woman or a young girl is sold into sex trafficking through multiple times of sex acts, including here in the city of Atlanta, where sex trafficking is prevalent, is one of the top 14 sex trafficking cities in the United States. And currently treating this as misdemeanors, we tend to make the trafficked woman or child, we hold them, it seems to be, to stricter rules and punishments than we do the individuals who are selling them, through intimidation and through providing them with drugs and trapping them in here, where these predators go into these at-risk communities and recruit these young ladies to come out and participate in this horrific life-changing experience. And then when they are finished with them, they basically throw them away, while at the same time we do little, if nothing, to the men in the state of Georgia who go out and purchase sex. Currently, pandering in the communities I represent is a misdemeanor, and if you are arrested for attempting to or picking up a sex worker and even offering to pay money to engage in sex, or you actually do engage in sex with this individual, the typical bond is $250. Once you pay that bond, you're released, and if you don't show up for court, that bond becomes the fine, and you go on your merry way, never have explaining to your wife or your girlfriend while you were 3 or 4 hours late for the dinner party or anything else. And all this does is continue to exploit thousands of women and children in the state of Georgia. And sadly, it seems that the children are getting younger and younger, these girls that are being sold. There was an incident in Columbus a few weeks back where a mother sold her daughter, who was 5 years old, I believe, to a gentleman for sex. He carried her across the river into Alabama, engaged in sexual acts with her, and then murdered the child. And for these types of actors to be allowed to go to the county jail and post a misdemeanor bond and get out is an affront to every female in the state of Georgia, and it's horrific. And I understand that there are individuals who do not like the fact that we take misdemeanors and turn them into felonies and all of this, and I respect their opinions. I respect their professionalism and their expertise, but in these cases like this, it's very clear the damage that's done by this. We're not talking about stealing a radio or we're not talking about breaking into somebody's car. We're talking about selling a human being under, in many cases, under no choice of their own, to another human being to be used for a short period of time, multiple times in a night or multiple times in a week. And we have gone out on these things in my career, and we've arrested 30 or 40 sex workers in a matter of a few hours, and then we put our undercovers out there and we continue arresting panderers, men who are out there looking to buy sex. We arrest 40 and 50 a night. And it's just disgusting, it's horrific, and we're better than this. So all I'm asking is that we upgrade pimping and pandering to a felony. So when those individuals are arrested and they do go to jail, they will have an opportunity to post bond and get back out into the community. And then when they go to court, they'll stand in front of a superior court judge as opposed to a state court judge or no judge at all. And there is nothing preventing them from offering a robust defense against the charge, against these horrific charges.
Thank you, Senator. Do you have any questions for Senator Robertson? Senator Kirkpatrick.
Thank you, Mr. Chairman. My question is, I don't have a code section pulled up, so is there any differentiation between adults and minors in the current code? Because I don't see anything about that in here.
Adults and minors, as far as those being victimized, right? If it were a minor child, it would move into the child molestation arena. This right here is just dealing with the individuals that pimp and pander. But if it were to be a child, then yes, there would be other charges on top of the pandering and or the pimping.
Any other questions for Senator Robertson? All right, thank you. I know we are down to 5 members. We do not have a quorum. This is a hearing only regardless, but there are 2 people who signed up to speak. I'll still let you be heard, but if you want to reserve the right to come back when everybody's here, I'll also give you that option too. But first, Taylor Hawkins with Frontline Policy. Good evening.
I'd like to reserve the right to do that, as if that makes more sense than doing it today. That's fine. Either one or both.
Well, it's up to you. If you want to share with us, that's fine. But if you want to wait and come back, that's fine too.
Gotcha. Well, I do want to go ahead and register. My name is Taylor Hawkins with Frontline Policy Action. Our organization is focused on promoting and protecting family and Christian values in the state. And we believe, we thank the chairman for his work on this issue. We believe that anything that protects the women and children of this state puts up an additional barrier between them and those who would perpetrate acts of violence, these heinous crimes against them. We believe those are good things, and those things will make this state a better state to live, work, and raise a family in. Whether you're a single mom, whatever your situation happens to be, those are heinous acts, and we believe very strongly that this legislation would go far to promoting those barriers. So we appreciate that, and we'd ask that this legislation be passed out of this committee.
All right, thank you, Mr. Hawkins. Any questions for him? All right, thank you. And Ms. Maisie Lynn Guertin?
I'll reserve, Chairman. Thank you so much.
All right, reserve. Okay. All right. Well, thank you all so much. That's the last bill on the agenda. Again, we'll be meeting tomorrow at 9 a.m. And we have someone that has agreed to bring breakfast for the committee members. So if you want to eat a late breakfast, we'll see you at 9 o'clock. Thank you all. We're adjourned.